police arrest two men. They have pretty good evidence that they are the right men. They've been identified by eyewitnesses from photographs. The two men are tried, they are convicted, and they are sentenced to 25 years. In the United States, murder carries very harsh sentences. In some states, it carries the death penalty. It can carry a life sentence, life without the possibility of parole. This was a 25-year sentence. Now, that's the background, and these two men go to jail. As the years pass, evidence comes out that there was a mistake. That in fact, these two men who claimed that they had never met each other, one of them says, I wasn't even there that night. Evidence begins to come out that in fact they're telling the truth. That in fact it was two or possibly three other men who had nothing to do with them who committed the crime. But for various reasons, even though this evidence begins to come out, the New York City District Attorney's Office doesn't do anything about it. The two men are still in prison as the evidence is mounting. The newspapers begin running stories saying there has been a miscarriage of justice and two innocent men are in jail. There is a television program about them. And finally, after they have been in prison for 14 years, the district attorney's office decides to reopen the investigation. And they appointed a veteran prosecutor, a man named Daniel Bibb, who is the main protagonist of my story. Daniel Bibb to reinvestigate the case. Daniel Bibb, working with police detectives, starts investigating from the very beginning. And it's an exhaustive investigation. It takes him 2.5 years to investigate it. He interviews 60 witnesses. He travels to several federal prisons. He travels to 15 different American states to visits prisoners in jail. I should explain that the people who are involved in this case, whether they are innocent or guilty, are not necessarily the highest quality of people in the society, and almost all these witnesses are found later on in various jails around the country. And after this lengthy investigation, Bibb decides that the two men were wrongly convicted and that they are the wrong men. They had nothing to do with the crime. He thinks that he knows who the real criminals are. He goes to his boss and says, I think that we should confess error. The boss says, no. There's going to be a fact-finding hearing to decide whether the two men should get a new trial. And Bibb says, I want to go to the hearing and say that we are dismissing the case, we made a mistake. And the higher-ups in the New York City District Attorney's Office say, no, go in and defend these convictions. And that's the point at which Bibb says, I went in, I did everything that I could to lose the case. Now, what exactly did he do? Well, first of all, in the course of his investigation, he had discovered and built a personal relationship with a number of these witnesses. These were witnesses who really were very reluctant to come to court and testify again. As I say, they are not the nicest people in American society. They don't like courts. Their attitude is, what's in it for me? And Bibb decided that he would persuade them to come to the court and testify. Now, usually, lawyers do not persuade witnesses to testify for the other side, but Bibb did. Secondly, throughout his investigation, every time he came up with evidence that the men were innocent, the men who were in prison, he is under a constitutional obligation to turn that evidence over to the other side. He did that. But then when he talked with the lawyers on the other side and discovered that they didn't always understand why this evidence was important, he explained the meaning of the evidence to them. And that also is something that in an adversary system is not done. The third thing that he did was that in the course of preparing his witnesses to testify, and I should explain that in American practice, it is not unethical for a lawyer to prepare a witness for testimony, to simply explain what's going to happen, explain what questions the lawyer is going to ask, and so on. Here, Bibb revealed to the witnesses the questions he was going to ask in cross-examination. That is, he said, you are going to be called as witnesses for the defense. Here are the questions they will probably ask you, and here are the questions that I will ask you, so that the witnesses knew in advance what questions Bibb was going to ask. Those were the ways in which he threw the case. And after that happened, the New York City prosecutor decided to drop the case against one of them. The second one, they continued to press the case. The man got a new trial. Bibb quit. He said, I've had enough. I'm out of here. And eventually he became a defense lawyer. In the meantime, another prosecutor was appointed. The case went to a trial. The man was acquitted. Both of the men had been in jail for 14 years. Both of them sued the city of New York for wrongful imprisonment. They both collected more than $1 million from the city of New York for wrongful imprisonment. Now, after the story came out, there was a lot of discussion about what Bibb had done, because this is a very unusual behavior for any lawyer in the adversary system. And several well-known legal ethics professors said what he did violated all of the rules of legal ethics. And I'll explain in a moment why that's true. And he should be disciplined for having deliberately lost the case. And in fact, a complaint was filed against him, but eventually it was dismissed, and so he was not disciplined. Now, why is it that he should be disciplined for doing this? I'd like you to imagine that he wasn't a public prosecutor, but that he was a private lawyer in a piece of civil litigation. And imagine that you are a private lawyer in a piece of civil litigation, and you decide that your client really should lose the case. And so before you go into the hearing, you tell the witnesses for the other side what questions you're going to ask them. You explain the meaning of the evidence to the other side. And in fact, you locate witnesses that will help the other side and talk those witnesses into coming to court. Under American rules, and I will leave it to you to decide whether the same thing would be true under Turkish rules, the lawyer would have violated many deontological standards. First, the standard requiring competent representation. Second, a standard that requires that it's the client, not the lawyer, who decides what the goals of the representation are. And in this case, the client is the state of New York, speaking through Dan Bibb's boss. Third, the prohibition on conflicts of interest, because after all, he is helping the other side in the case. Fourth, the requirement that the lawyer should be diligent and zealous on the side of her own client, not the other's client. And there might be others. It could be that Bibb had misused confidential information by using the results of his investigation. It could be that he had deceived his superiors by going ahead with the case rather than resigning. In other words, if he were a private lawyer in private practice, there's no question that Bibb would have committed a mountain of ethics violations and should have been disciplined. What makes it different when he's a prosecutor? Here, there is one principal thing that makes it different. It's not a rule in the American rules of deontology. Rather, it's a principle that lies throughout the discussions of the prosecutor's role, and that is that a prosecutor should not seek victory, but should seek justice. This is a very difficult saying for prosecutors because, of course, it raises a difficult question. What exactly is justice? It's a philosophical question. Prosecutors are very often practical people who are uncomfortable asking deep philosophical questions like that, and they are not confident of their answers to the questions. Here, I want to say simply that in Bibb's case, You don't need a philosophical theory of justice to recognize something that is a deep injustice. And I think that the theoretical point of interest is that oftentimes our sense of injustice is more reliable. We can know it better, we can recognize it better, even without a theory, than our sense of justice. We oftentimes disagree in hard cases about what justice is, but in cases like this, the sense of injustice is something that is very deep. Bibb realized that this result, keeping 2 innocent men in prison for 11 more years, would be a tremendous injustice. He also realized that because he was the only person who actually had built up a relationship with the reluctant witnesses, that if he didn't persuade them to testify, they wouldn't testify. There's a chance that the sentences would be upheld and the men would continue to be in jail for 11 more years. So where some, as I say, some ethics experts commenting in the newspapers said that Daniel Bibb should be disbarred, should be punished, my reaction was that he should be given a medal because he actually sought justice, not victory. Now, there are 2 other significant issues in this case, and I want to mention them, but it's a long afternoon, it's a warm day, and I don't want to strain your patience too much. I will then just leave them to my colleague to comment on. One is the fact that Bibb was not the boss. He was a lower down lawyer in the organization. And in fact, his boss is an elected official of the state of New York. And when I first wrote about this and said that Bibb should get a medal, this was on the internet, several very distinguished colleagues said, "What are you talking about? Daniel Bibb is not the district attorney of New York. The elected official is. A lawyer should have a little bit, a lawyer in a subordinate position should have a little bit of humility. Presumably your superiors have looked at the evidence and they've decided that you're wrong and that you should go ahead with the prosecutions. You should not break hierarchy." And in fact, one of the commentators said, hierarchy is process. My response to that, in brief, is that that is generally true, and that a lawyer who thinks that the superiors in the law firm, in the prosecutor's office, are wrong, should be a little bit humble and think, well, maybe these people understand the case better than I did. Maybe I have become too invested in my own opinion and I should be more objective. Here, it seems to me that wasn't the issue, because Bibb's superiors didn't know anything about the case, about the reinvestigation, except what he himself had told them. So here it would have been artificial for him to say, well, maybe they understand the case better. Why is it that they didn't allow him to drop the case? I talked with Dan Bibb. I asked him that. He said, I can't talk about the internal deliberations in the prosecutor's office. He's right. That's privileged. That's confidential. He would have been violating his professional duties if he had told me what the secret conversations were among the prosecutors. So you can only guess. Maybe it was that they thought it would be politically damaging to confess error after 14 years. Maybe it was simply the fact that in a bureaucracy, oftentimes nobody is willing to step up and take the responsibility of correcting a mistake. I don't know. We can only guess. But I don't think that hierarchy as process is the governing value here. And that takes me to the last issue, which is the one that Professor Moragawa talked about. Professional ethics, is it professional or is it personal? Here I'm afraid I'm going to have to disagree with him. He said that ultimately it's professional. I think that it begins as professional. Ultimately, it is personal. Here you had a man who is in the position that he is the only one who could prevent 2 innocent men from spending 11 more years in jail. At least as he understood it, he was the only one who could do it. I mean, we don't know what the judge would have decided, how the case would have come out if he hadn't thrown the case, but that's at least what he knew going in. And sometimes it seems to me that when you're confronted with such a grave injustice, the personal takes precedence over the professional. And here I'd like to go back to the very beginnings of philosophy, to Socrates, who in his apology, this is his own defense speech when he was on trial for his life, said, you know, I have something inside of me. It's a daimon, is the word he used. It's the voice of conscience. It's an inner voice. It never tells me what to do, but sometimes it tells me what not to do. It tells me when I'm about to do something that's wrong. And then Socrates gives two examples. He said once, when we had tyrants ruling the city of Athens, they asked a group of us to go and arrest an innocent man named Leon. The others went out to arrest him. I just went home. The other was when the Athenians were angry at some of their admirals in the Navy because they had lost a crucial naval battle and they were going to try them and sentence them to death. Socrates thought that would be unjust. And even though he was under a lot of pressure to vote to convict them, he decided that he wouldn't do it and didn't. Now, the only point that I want to draw from this is a very simple one. Here you have what in philosophy is perhaps the first analysis of conscience, an inner voice that tells you what not to do when you're about to do wrong. And what are the examples that Socrates uses to illustrate it? It's somebody who's confronted with the possibility of an unjust legal conviction and decides to act on the demands of conscience rather than the demands of the authorities. So those are the levels of the case. I mean, just in a quick summary, the role of the lawyer in the adversary system of justice, and specifically the role of the prosecutor, who is required to seek justice, not victory. Secondly, the role of a subordinate lawyer in an organization who is being asked to do something that he finds unjust, but that his superiors keep telling him to do. And third, the role of the personal conscience over professional conscience. Now, when I talked with Dan Bibb, he had one very interesting reflective moment. There was a lot written about this case in the American newspapers and in law reviews. And he said to me, you know, it's really difficult to have your entire life turn into a case. I'm not a person anymore. I am a case. All of those years of hard work, all of those years in which I put bad guys in jail doesn't seem to be remembered. Now I'm remembered for just this one thing. Oh well. Now, when I talked with him, he was a man who used very earthy, salty language, which I don't want to repeat here. He was a practical man. He was not, I think, a saint. He doesn't pretend to be a saint or a moralist, but he was somebody who, when push comes to shove, decided that conscience would prevail. Thank you very much.
Profesörümüze çok teşekkür ederiz. Tartışmacı olarak Profesör Doktor Brent Vivander'i konuşmasını yapmak üzere kürsüye davet ediyorum.
Thank you, and at the risk of growing repetitious, let me again thank all of the organizers of the conference here in Oxford and also in Ankara for a wonderful introduction to a country that I hope to visit again many times. I very, very much enjoyed my trip to Turkey, and I appreciate the opportunity to talk a little bit with you and to continue a debate that I've had with David on the internet and friends about the Daniel Bibb case. And it is an excellent vehicle for talking about this question of whether legal ethics of lawyers is personal or professional. Now, what I'm going to do, I'm going to reveal my method a little bit right now. I'm going to raise the balloon back up from the ground to 1,500 meters or so. And in doing so, I'm shifting the ground, and that might be a little tricky on my part. Common law trained lawyers have a saying, if you don't have good law, pound on the facts. If you don't have good facts, pound on the law. If you don't have either, pound on the table. That's what I'm going to be doing. I'm kind of shifting the ground from the very concrete, practical details of this case to more abstract theoretical considerations. What that tells you is, I think I've kind of lost on the facts. My factual argument here is cooked, especially when I read the subsequent paper, this paper that you have, which has a lot more factual detail in it. It really does seem like these two guys were innocent, and that Bibb was right about that. But when I first started following this case, it was unclear. And it got me thinking about legal ethics in terms of this personal versus professional, or as I sometimes call it, institutional way of looking at the question. And it fits in nicely with my general approach to legal ethics, which is to think about the lawyer's role not so much as morality, ordinary ethics, but as politics, a kind of special morality of political or institutional roles. And I'll give you a couple of examples. Those of you who know the philosophy of John Rawls will be familiar with this move. Rawls says, in political theory, the philosophical conception of a person is replaced in liberal political theory by the political conception of a citizen. Similarly, all of you who are lawyers understand that the concept of the rule of law is an evaluative concept, a normative concept that makes use of a lot of values such as impartiality, commitment by the government to be bound by general rules, as Professor Morikwa said earlier, the idea that right, not power, should determine outcomes. These are all normative considerations that go into this notion of legality, but they're not the same as ordinary morality. They're not the same as the morality of things apart from political roles. And I believe that lawyers, judges, prosecutors, all of these officers who are bound up somehow with the legal system ought to be evaluated in this kind of political and institutional way. So in the Bibb case, when Professor Luban says that Bibb deserves a medal, and Stephen Gillers, who's a well-known commentator in the U.S., says he should be disbarred, I think you can see that they're standing on these different grounds. Professor Gillers is standing on the political ground, saying, as a political actor, qua participant in an institutional process, Bibb is wrong. Professor Luban says, quite eloquently with the reference to Socrates at the end of his paper, that as a person, qua ordinary human being, Daniel Bibb did right and deserves a medal. No, he's not a saint, but he followed the dictates of his conscience, and he should be praised for that. And so really to decide who's right, Professor Gillers, Professor Luban, we really have to take that theoretical perspective, climb up in the balloon a few thousand meters, and decide whether we're talking about political concepts, like citizenship, or moral concepts like the person. What are we doing when we do legal ethics? Now, in the Bibb case, notice in Professor Luban's presentation that it was only at the end that we got any sense of the institutional context of the decision-making process. We heard a lot about the facts, but the facts came to you as given. The facts were stipulated. Now, this is something that we, teachers of first-year law students in the U.S., caution our students about. We say, notice that when you read judicial opinions, they are appellate court opinions, and the judges state the facts as if they are simply true. But when you go out into law practice, you realize that facts aren't either true or false. They're the sort of thing that have to be proven. They are the conclusions of arguments about how to characterize evidence. So there's a distinction between evidence and facts. Judges, when they make decisions about the law, deal with facts. They have this luxury. Lawyers, when they deal with real cases, have to deal with evidence. They don't have facts. They're characterizing evidence. They're trying to figure out what to do. All of the facts that we heard were stipulated. Now, Professor Luban later came back and said, well, you know, there might be some disagreement, but that was after he'd already loaded the discussion up. And that's okay. It's a rhetorical technique that American lawyers use all the time. They get you to think about the facts in a particular way. They get your sympathy. They get you to say, yeah, those guys were innocent. He did the right thing. And only then does it become clear that, well, we're not quite sure, right? Bibb was one actor. Bibb was one participant in the decision-making process. But I think we should see him as a actor, an input, a participant, but not the process. And I think it's important to situate lawyers and prosecutors and judges in these institutional contexts and not see them as freestanding actors. The American and English references inevitably to Daniel Defoe's novel Robinson Crusoe, where a person is shipwrecked and finds himself on an island and kind of recreates human society by himself as the only member of it. Lawyers aren't Robinson Crusoe. Judges, prosecutors aren't Robinson Crusoe. They act in communities. They act in institutions. And Daniel Bibb's views about what ought to be done, his beliefs about who did what, his beliefs about the innocence or guilt of these guys he was prosecuting, are simply inputs into the process. They should not be regarded as conclusive about what ought to be done. They're not the conclusion of the process. They are simply inputs into the process. Now, I think where Professor Luban is coming from, and this can be seen in a lot of his other work, is a tendency in legal ethics scholarship to pervasively mistrust institutions. And I understand that, and I don't have to tell a European audience that states can do horrible things, and that political institutions can perpetrate monstrous injustices. That is the, if anything stands out as the lesson of 20th century history, it is that institutions can often do wrong. But I think it's important not to lose sight of the fact that institutions can also be right. And in our reaction to the horrors of the 20th century, or somewhat scaled down, reaction to some of the social scientific experiments that are very well known, like the Pilgrim experiments, that demonstrate that people can act wrongfully when they act in concert with others. I think it's important not to overcorrect in the direction of mistrusting institutions so much that we automatically assume that when an individual acts against an institution, Daniel Bibb versus the Manhattan DA's office, Bibb has to be right. We've heard so many stories about whistleblowers, these heroic individuals who stand up to the power of the institution, that I think we tend to assume that the individual has to be right. Now, again, this is where I shifted from the facts to the theory, because Daniel Bibb probably was right. But it's not necessarily the case that the individual is always right, and there may be a very good reason to rely on institutional decision-making processes in many cases. One of those reasons is that our society, and this is probably true of Turkish society as well, as far as I can tell, is characterized by pervasive disagreement. We disagree about everything all the time. That's okay. That's one of the things that makes society kind of fun. But it also makes it difficult to figure out what ought to be done, and in particular, to figure out what ought to be done in the way Professor Morihiwa referred to earlier, as a matter of right, not a matter of power. If we have disagreement and we have individuals who act because they believe this is the right thing to do, there is a risk that they may act because they have the power to do so. They may act out of fiat, not out of right. The way to ensure that decisions are made on the basis of right, not power, is to insist that they be made lawfully. And for decisions to be made lawfully means they have to be made institutionally. They have to be made as part of a process that collects the views of many people, that takes into account the input of many different citizens into the process, that comes up with a procedural resolution of the disagreement, and that uses, and here's that word, hierarchy, to determine what ought to be done. I like this idea that hierarchy is process, and in large, complicated institutions, hierarchy may be process. But I want to resist the idea that this is an immoral thing or an amoral thing. This may be something that reflects the moral value that underlies institutions. And that moral value is this idea of impartiality, right not power, the rule of law, the political conception of legality, not the ordinary moral conception of justice. Now, I always find it very strange to go to legal ethics conferences and say lawyers shouldn't be concerned with justice. But I like the way Professor Morihiwa set up the panel by saying lawyers are concerned with justice, but it is justice as law. The justice we are concerned with as lawyers, and that's true of prosecutors as well, is legal justice. And legal justice, in my view, is institutional. And I think we should be very cautious not to quickly go to Socrates' demon as the touchstone of decisions. Now, I will admit that there are occasions in which institutions perpetrate injustice, and we want individuals to exercise conscientious objection. We want individuals to push back, opt out, resign, blow the whistle, whatever. That may be exactly the right thing to do in all cases, but all I insist on, but I think this is an important point, is that lawyers stop and consider very carefully the reasons that they have for acting with fidelity to law and also due regard for institutional processes, even these things like these intra-office review processes, which are used to aggregate the views of many people into one thing, which is the social decision called a right, which is distinguished from power. That's the essence of the rule of law, and that's the moral value, and it is a moral value. That's the value to which we as lawyers ought to be committed. So, thank you very much.
Bu arada masa konuşmacıları Karl Bear bence konuşmasını yapmak üzere kürsüye davet ediyor.
Just waiting to see how the argument goes on the bench here among the Turkish lawyers. Is it okay? Well, first of all, let me introduce myself. My name is Karl Levenaars. Excuse me for being underdressed, but they said that I hadn't put on a tie, so excuse me for that. But I'm a lawyer in Belgium, in Brussels. I was the head of the bar in Brussels, and I have been for quite some time a member of the CCB, and on the CCB I was responsible for what is called the Working Party on Corporate Social Responsibility, and I have been given also the responsibility of chairing the Committee on GATS, which deals with the liberalization of legal services, where we do not, as a CCB, favor the liberalization of legal services that would do away with the specificity of the legal profession. I'm saying this to you, to the lawyers, I'm saying this to the local bar and the Turkish bar, which is very well represented on the CCB as an observer. After this introduction, let me then say a few words about what I heard, purely as a lawyer, but as a lawyer familiar with the civil law system, and perhaps not as familiar with the common law system. I may have studied, or at least done an LLM in the United States, and I may be a little bit familiar with the American system, but certainly not to that degree that I would dare to make a value judgment on what we have just heard. Let me say that indeed I was first listening to the first expose, which ended with Socrates, and something which ends with Socrates must be the truth, of course. I was very much carried away by your argument, and then I felt also that the public prosecutor, who was in fact a lawyer, that he deserved a medal for being so stubborn in trying to bring the truth to prevail. But when I heard what a major effort that requires in the United States in order to have a case retried, when it would appear, even at face value, that there has been a false conviction, etc., that it takes, I don't know how much money that could be, and that the state is paying for that, for all the visits, for all the travel which has been undertaken. I do not really know whether I should admire this or whether I should pity the system. Should you have in the United States a different system which would make it more easy for Mr. Bitt, first of all, to do what he did, secondly, that he shouldn't have to resign, and thirdly, that he should just not be remembered simply as a case? Very, curious, very particular aspect of the American way of doing it. And then we had the second expose. And the second expose, I was not sure whether I was still hearing an American lawyer speaking. He sounded to me very much as if he had spent his whole life in Europe or in Turkey, in an institutional framework where hierarchy is very much respected and where hierarchy decides what the so-called lower-ranking individual should do, should think. Hierarchy is thinking on behalf of its members. And then I said, I myself, after so many years of practice, even not as a criminal lawyer, is that a good system in Europe on the continent? Do we really want the hierarchy to think for us? Can we not, as members of the Public Prosecutor's Office, at least think for ourselves? Now, I think there is a bit of a misconception in what I'm saying now, and I'm sure that there are distinguished members here from the Turkish bar, but certainly from the Turkish Public Prosecutor's Office who will correct me. But looking at our not only continental system, but at our Napoleonic system, semi-French system, we have on the one hand the public prosecutor, and the public prosecutor is indeed independent. He is not, in most states, certainly not an official of the government. He is not an official of the Minister of Justice. The only thing that the Minister of Justice can do in certain countries is to instruct the public prosecutor to open the case and to investigate the case. He can never, of course, instruct the public prosecutor to do otherwise. That is the system. The Public Prosecutor's Office is independent. The Public Prosecutor's Office is there not to seek victory, but to seek justice. And to see to it that justice is done, is seen to be done, and is done on behalf of public interest, not on behalf of any individual being there. Secondly, when there is an investigation, as in the BIT case, the investigation would have been conducted in France and Belgium and a few other countries, not by the Public Prosecutor's Office, but by the examining magistrate, the juge d'instruction. The examining magistrate is part of the bench, is not part of the Public Prosecutor's Office, and he will carry on his investigation, as we say in French, à charge ou à décharge. He will try to prove right or wrong, and he will gather the facts. And he has the largest possible independence in trying to gather the facts. Ultimately, he presents the facts to the Public Prosecutor's Office, and the Public Prosecutor's Office decides to press charges, to press the case, or not press the case. Does that mean that in our continental system, we will not talk for the United Kingdom, but does that mean in our continental system that no people have been wrongly condemned and wrongly sent to jail? No. But does it mean that we need an ultimately complicated process like in the United States to get the case retried? And the answer is no. It is rather simple. You go to the Supreme Court, you present the facts which are not a proof of innocence, but in fact you present the facts showing that there was a conviction as obtained was not based on solid evidence. And in principle, an enlightened bench, provided of course that the judges are enlightened, but take that as a premise, will in principle then acquit. I just wanted to say that to our American colleagues, who of course know a lot about Europe, and try to convince them the marvelous system we have, nevertheless, isn't, and I express myself to you, don't you think that our system in Europe and in Turkey, compared with the United States, is a very boring system, and that the nicer system with the good facts, which read like a novel, is the American system. I thank you very much.
Thank you very much, Carl, very much. As moderator, we do have a bit more time, and as Carl has suggested, if there is anyone from the Turkish audience that would like to comment on what we have discussed so far, please raise your hand. Okay. Yes. Can you Microphone. If there is no microphone, can you come up here? Because the simultaneous translator cannot understand. Okay. Can you identify yourself first?
Merhaba, hoş geldiniz öncelikle. Ben avukat Eğitim'im.
Mike, turn on the mic.
Merhaba.
Still on.
Oraya geçeceğiz. Bence daha garanti. Hadi.
To save time, come here.
Merhaba, öncelikle hoş geldiniz. Ben avukat Eğitim'im. Az önce tartıştığımız bir davasında bence insanların yargılanması ve ceza yemesi sırf devletin kul bir duruş olsun diye savcının cezalandırılması bana hem insan olarak hem bir hukukçu olarak çok yanlış geldi. Çünkü biz devletiz ve kul bir duruşumuz olsun. Bu nedenle insanlar yanlış olarak cezalandırılsın ve bundan dolayı da biz yargılamamızı yapmayalım. Bence çok yanlış. Ben sadece bir yorum yapmak istemiştim. Teşekkürler.
Thank you very much. We have more time. Someone else. Yes, please. Professor Kutiyar.
Ben sayın birinci konuşmacının dediğini madalya vermesinden yanayım. Neden? Kurumlar niçin var? Kendileri ayakta durması için mi? Yoksa insanlara hizmet etmesi için. Adil yargılanma hakkı zedelenmiş olan insanları kurtarmaya çalışıyor ve sistem sıkıntılı bir hal soktuğu için dolaylı yollar arıyor. Ama ne istiyoruz? O insanlar daha 11 yıl hapiste mi kalsın? Dolayısıyla hiçbir kurum savunulamaz. Kurumlar, hukukla ilgili kurumlar adaleti gerçekleştirmek için varlar. Devlet kurumları da bunun için var. Dolayısıyla burada hiçbir tartışma bile ihtiyacını görmüyorum. Tartışılacak bir şey yok. İnsanlar adaletsiz yargılandı. Zaten 11 yıl, 14 yıl kaldı. Ondan sonra da bir 11 yıl daha kalsın. Demeye hakkımız yok. En basit ifadesi adil yargılanma hakkına aykırıdır. Ama çok daha temel bir şeyler. İnsanlığa aykırıdır. Bunu söyleyenin insan onuruna aykırıdır. Teşekkür ederim.
Thank you very much, Professor Kutiyar. Brad Liddell, would you like to
I'll try to answer without setting off the feedback. Please bear with me. Hey, it worked, okay. I appreciate that response very much, and what I really would need to do in order to defend myself is find the mirror image case of the Daniel Bibb case. I'm confident that they exist, I just don't happen to have one, so I now have an assignment to go back and start reading the newspapers and finding a case where the following thing happens. A prosecutor becomes convinced that two defendants are wrongfully convicted and are spending time in jail. He then spends millions of dollars of taxpayer money flying around to 15 states, interviewing people in jails, invading the privacy of many, many people who would like not to be dragged into this affair, putting their names in the newspapers, having an expensive public proceeding, and ultimately harming the name and reputation of innocent people, all on his own personal belief that there was a wrongful conviction. despite the view of that lawyer's supervisors and other lawyers in the office that he's simply off on a kind of, the English idiom, wild goose chase, off on a crazy quest on his own. This case works because Bibb was right. There are lots and lots of cases in which prosecutors would not have been right and might have caused a lot of damage and harm to innocent people. And that's the concern here. So this case works beautifully on these facts, but the argument that I made, and the reason that I talked about going to a higher level of abstraction, is that in the aggregate, all sorts of different values, including the privacy interests of innocent people, need to be taken into account when prosecutors decide they're going to go off on their own and act on what they take to be the just thing, rather than doing what their office is set up to do.
Thank you very much, Professor. Anyone else? I see a hand up there. Please come on.
Buyurun.
Avukat Selvi Turgut, öncelikle Aksaray'a hoş geldiniz diyorum. Burada tabii ki öncelikle bir kutlama gerekir. Niye? Avukat Selvi Turgut, öncelikle Aksaray'a hoş geldiniz diyorum. Burada öncelikle tabii ki bir kutlama gerekir. Niye? Çünkü maddi gerçeğin ortaya çıkması için çalışmıştır. Ama burada şu etik soruna bakmamız gerekir. Burada niye hukuk kurallarına ters düştü? Yani buradaki sorun hukuk sisteminden kaynaklanmaktadır. Son konuşmacı arkadaşın söylediği gibi burada iki farklı sistem vardır. Amerikan hukuk sistemi ve kıta Avrupası hukuk sistemi. Bizim hukuk sistemimize dönüp baktığımızda öncelikle savcılık makamı devlet kurumu içinde yer almaktadır. Ve savcılık makamının görevi kişinin ceza alması değildir. Savcılık makamı asli görevi maddi gerçeğin ortaya çıkmasıdır. Ve maddi gerçeğin ortaya çıkması için de sanığın lehine ve aleyhine olan tüm delilleri toplamak savcılık makamının görevidir. Bunu tabii ki değerlendirecek olan yargıç bu kanıtları değerlendirecek olandır. Ama tüm bu delilleri toplamak dediğimiz gibi savcılık makamının görevi olduğu için bu sistem biraz daha savcıya geniş yetki tanımakta, biraz daha bu tarz durumların ortaya çıkmasına engel olmaktadır. Bunun yanında tabii ki şöyle bir durum var. Burada da kanıtların değerlendirilmesi de çok önemlidir. Burada bu kişilerin mahkum olmasındaki kanıtlar neye göre verildi? Kaldı ki yine hukuk sistemimizde kanıtlarda şöyle bir durum vardır. Bu kanıtlar sanığın suçlu olduğuna yetecek derece değilse şüpheden sanık yararlanır karinesi vardır. Bunlar bir bütün olarak değerlendirilmesi gerekir. Yani burada şuradan dolayı zorlanmaktadır, sistemden kaynaklanmaktadır. Kaldı ki bizim hukukumuzda da şöyle bir durum vardır. Amerikan hukuku gibi ayrı bağımsız olmadığı için, yani savcılık büroları bağımsız olmadığı için aynı davada o şeye katılan, kovuşturmaya veya soruşturmaya katılan savcı daha sonra burada gerek müştekinin avukatı veya sanığın avukatı veya aynı davada hüküm veren yargıç konumunda olamamaktadır. Bunlar bir bütün olarak değerlendirilebilir kanısındayım. Teşekkür ederim.
Thank you so much. Professor Newman will comment here.
I'd like to make two brief comments. The first is that I don't actually think that the original conviction of these two men was an unfair trial or a mistake. There was a lot of evidence against them. The evidence that showed that they were the wrong ones came out years later. And so I think that if there's a flaw in the system, the major flaw was simply that the prosecutor's office in New York, which is very large, is a bureaucracy. It seems to me that all large justice systems have bureaucracy. Bureaucracy has some problems. One problem is that it tends to move very slowly. A second is that bureaucrats tend to behave in a way that oftentimes is designed to protect the institution rather than to fulfill the institution's mission. I find it very hard to believe that any justice system that involves a large bureaucracy wouldn't have parallel problems. The last thing that I'd like to mention is we've seen in this case a tension between the personal and the professional morality. My own preferred way of dealing with this is let's change the professional morality so that in the future this tension is less. And that is actually in the process of happening in the United States, where the American Bar Association has put in new rules for prosecutors saying that if you're a prosecutor and you find evidence that a conviction has been wrongful, you have to turn it over to the lawyer of the other side, and you have to call the attention of the authorities to it. So that if that rule had been in effect, I think that Bibb would have had no problem, and there would have been no disciplinary action against him. I think that the problem was simply that the standard that he was following was the standard of seeking justice, not victory, where it's very difficult to say what, in the abstract, seeking justice means. And I think this is not just an American problem. Thank you.
Thank you very much for a very constructive comment. I have time for maybe one or two more short comments. Okay. Thank you very much for participating in this very, very important and complicated question. I hope that will initiate further inquiry into these fields of legal ethics in Turkey as well as elsewhere. Thank you very much.
Kaçar mısın?